How you doing? It's Jason Tolerico of One Timers. And when people got out of the 2020 February bar exam, I heard things about the performance test and the professional responsibility essay and little difficulties that students were having with it. So when they released the questions, I decided to take a look over it, and I said to myself, maybe this is what they need. So what we're going to do is we're going to go through the 2020 February bar exam question 2. You can find it on the State Bar's website right now. And let's take a look at it. So let's walk through it together. Go to the call to question first. And when people go to the call to question, I think what they miss is they just read it because that's what they think they're supposed to do. They check the box. You have to understand the purpose of why you're doing it. Make sure you understand what the examiners are asking, because ironically with the call of the question, you can almost figure out the fact pattern. And I'm sure many people who went through this didn't even acknowledge that. So number 1, with whom did Linda, and you know L is a lawyer, A is attorney, C might be client, or whatever the case is, D is the defendant, P is plaintiff. The State Bar doesn't play any tricks. There are absolutely no tricks on the bar exam, and if you're looking for them, you're never going to find them. With whom did Linda establish an attorney-client relationship? So that's the first thing. Who's the client? And to me, if they're asking who's the client, I assume there must be 2 parties involved. I think partnerships, I think premarital agreements, I think employees of corporations. Those are issues that are common in the profession of when we have, like, well, which one's the client here? And the lawyer has a duty only to the client, not to the other party. That's why it needs to be explained who the client is. That's your first call. Who is the client? So I know there's going to be 2 people there. The next thing is, and what, if any, ethical violations did Linda, the lawyer, commit at the time of the attorney-client relationship? So violations, so this is for number 1. Violations at time. That's at the time of signing. So something happened where if you could just guess right now what that violation would be. Maybe she accepted payment from a third party. Maybe she didn't explain who the client was, because lay people don't often understand. In fact, they almost never understand. And I'm sure before you went to law school, you may have not had any experience with this. You don't realize that the person that you're there with, whether it's your spouse, your partner for a partnership agreement, your interests are actually diverse. So the lawyer has to explain, look, this is my client, you're the one hiring me, and I have a duty to this person, I have no duty of confidentiality or any kind of ethical obligations to the person who's not. And that's what this essay turned to be about. All right, so we have number 2. What are Linda's ethical obligations in regard to Ellen's employment agreement? Well, why do I think Ellen's probably going to be one of these 2 parties? And now they're talking about an employment agreement. So guess who the other party is probably going to be? The employer. So I'm already starting to see the picture of what's going on. If you're using checklists, if you're using templates, if you think that skimming it's going to work, you're missing the point of the bar exam. The examiners are really laying it out for you. They try to make it as easy as they can. This is a state licensing exam. They cannot hide the ball. It's testing minimum legal competence. So we have the employment agreement, that's 2A. And you see how there's, it's just starting to come together. And 2B, what are Ellen's ethical obligations with regard to Ellen's request for confidentiality regarding the source of the survey data? So we're talking about the duty of confidentiality. There you go. All right. Don't have the biggest whiteboard here. So, all right, let's take it from the top now. And when you read this exam, make sure you read the fact pattern several times. I'm assuming you might have read it once or twice right now, at least, or maybe you've taken the bar exam. I'm going to walk you through it slowly and show you exactly what the examiners are doing and how easy this is to solve. So Linda is a lawyer with experience in representing small business. She usually represents the employer. So she represents small businesses. Probably doesn't represent clients. The examiner's already starting to tell you who the client is. And if I had to stop right there and somebody put a gun to my head and said, answer this in 2 seconds, I'd go the employer, and I'd be right. Both for-profit and non-profit. Well, why does that matter? It actually does matter a little bit in the facts, but I guarantee we're going to probably have a corporation that's for-profit, or we're going to have a non-profit, because the examiners are starting to lay that out. Non-profit is a newly formed California corporation. When I think newly formed companies generally don't have a lot of startup capital, don't have a lot of employees. I mean, every company that's in its embryonic state didn't start off huge. I mean, look at Amazon. They started in his garage. Same thing with Steve Jobs and Apple. So They didn't have a lot of money, so that's what I'm thinking about newly formed. It doesn't apply in this essay, but you don't know when it's going to apply. The point is, I just want you to be thinking about the fact pattern. A newly formed California nonprofit or corporation with few assets and limited income. Generally, that's how it works. Nonprofit is governed by a volunteer board of 3 directors, one of which whom holds the position of the board chair. The board chair, that tells me that's the highest person on the totem pole, and the board of directors is the highest of a corporation. For those of you that are familiar with business associations, board of directors the shareholders actually own the company, so they're the ones who hire and fire the board of directors, who in turn get the officers, and the officers in turn hire the employees. That's how the corporate structure works. Nonprofit's only employee is Ellen, who has no official title. Well, we just learned about Ellen down here, and that's their only employee. So why do I think they're going to probably enter into an employment agreement? Nonprofit and Ellen. And if you can't see that by reading it now, you're not thinking carefully, you're not slowing down enough to really process what the fact pattern's going. And if you think you don't have enough time to do that, you're absolutely wrong, because you're going to save time by not writing about things that aren't there. Ellen contacted Linda and said that nonprofit would like to retain Linda. Stop right there. Who's the client? Well, that's obvious. Nonprofit. We have 2 strong facts that say that. 2 actually dispositive facts. Number 1, Linda represents small businesses. Number 2, nonprofit would like to retain you. And if you can't see who the client is from there, you did not read carefully and didn't slow down and actually think. Don't skim these fact patterns. You're not going to find this in a template. You're not going to find this in a checklist. You're going to find it up here, just based on common sense and what the facts are trying to tell you. Would like to retain Linda to help it develop a formal employment agreement with Ellen to make Ellen officially the executive director of the nonprofit. So now Ellen's coming into my office, says that her company wants to hire me to write an employment agreement for her. Stop the presses. Because right there, I have to tell her, nonprofit is the corporation, or no, excuse me, the client, not you. Your interests and nonprofits are diverse. So what I would tell Ellen right there is, I probably need to speak to someone else from nonprofit. Of course, always get the retainer agreement inside and take the money. That goes without saying. I mean, you're a lawyer, for God's sake. You got to pay off your debt. But you have to say to Ellen, maybe at the beginning of this towards the end of the conversation, once you learn the interests are adverse, you have to explain who the client is. And then you would tell Ellen, you need to seek your own independent counsel because I'm not your attorney, and any discussions between us are not privileged. You don't need to really memorize law to understand that, how that works. If you went to law school, you're familiar with professional responsibility, you can kind of figure that out. Even if you don't hit every single little basis, you're going to be competent enough to at least get a passing score, and the goal is to pass. Okay. Ellen's position as executive director would make her an officer in the company, but not as a board member. Well, what does that mean? That means there are people above her. So the lawyer can go above her head if there's a problem with Ellen. And it turns out there's a problem with Ellen because she's trying to defraud the corporation. Linda agreed to accept the matter. So the whole issue here is, who's the client? Explain to Ellen why she's not the client, who you represent, who your ethical obligations are to, and that she should seek independent counsel. Now, the final sentence goes to the last issue. Linda did not memorialize her agreement in writing. Okay, well, California has a very strong preference for putting things in writing, where the ABA doesn't. The big difference between the ABA and California are 2 things, and I tell you that 85% of the difference is in really one sentence. In California, they want everything in writing, and they have strict confidentiality rules. So if you're a lawyer in California and you want to follow the California rules of professional conduct, carry a pen and keep your mouth shut. That's the best thing you can do for the duty of confidentiality. That's California rules in a nutshell. Put everything in writing, keep your mouth shut. You're not going to get in any trouble. Okay, and don't read people off. So if you notice, the first 2 paragraphs go to call 1. The last paragraph goes to call 2. And this is not an anomaly. It's almost on every single essay. You'll notice that certain paragraphs go to certain calls because that's how they have to write the exam. Okay, so does Linda need to put this agreement in writing? Under the ABA, the answer is, well, they prefer it. It's not required, it's not mandatory, but it's a good idea, so ABA is preferable. California is the real rule that they're getting at here. So, when does it have to be in writing Generally, it has to be in writing. There are a few exceptions. Well, if it's not going to be over $1,000. Well, don't forget, they do not put a dollar amount here for a specific reason. And the reason is because how much is this going to cost? Okay, if you don't, and there's no right answer. I don't know what employment agreements cost. I'm sure it'll take Linda a couple hours, maybe at $250 an hour, probably right around the $1,000 mark. I would put that in my discussion. That's what they're looking for. So if it does go over $1,000, it needs to be in writing. If it stays under $1,000, it doesn't have to be in writing. So one of the two. But there's a catch. There's one more thing here, and that is, who does Linda represent? She represents nonprofit. They're a corporation. It says so right in the facts. And in California, agreements with sophisticated parties, like with agreements, the corporations call them sophisticated parties because they are the corporate structure. You have to know something about setting things up. Agreements with corporations do not need to be in writing. So either way you slice it, if nonprofit is the client, no matter how much it costs, it doesn't have to be in writing. But if Ellen was the client, then it would have to be in writing, assuming it goes over $1,000. That's what the examiners are looking for. And if you don't believe me, wait until the sample answers are released, take a look at them, and you'll see that the two top answers in the state discuss that exact issue. And if you didn't see that, not too good. Because those are the little things you have to catch. All right, so moving on, second paragraph goes to second call. Ellen drafted an employment agreement that included a proposed salary and sent that agreement to Linda. Ellen does not understand who, Ellen really thinks that Linda is her attorney, and that's why she's sending it to her. And essentially the violations in call 1 were that it should have been explained at that time to stop it. And right now is not even a bad time to start explaining it, and Linda's committing an ethical violation by allowing this to continue. Ellen told Linda that her proposed salary was data-driven. Well, I remember reading that in call 2B, from a survey of similar positions, but based on the for-profit field. Now, I don't know about you, but I'm not quite sure if a nonprofit worker or a profit worker makes more money. I assume the profit worker probably does, so we don't have enough information yet. So when you keep reading the fact patterns, it'll iron out. Ellen asked Linda not to tell the board about the source of the survey data. Well, that's why you needed to explain to the client at the time. Well, you needed to explain to Ellen, who's not the client, I'm not your attorney. The conversations between us are not privileged. If Ellen knew that, you think Ellen would be sending this to her? Not at all. So do you see how it all kind of spirals out in the legal field? And that's why we have this fact pattern, so you can analyze that. So Linda needs to tell her it's not privileged. And so what Linda needs to do is go above Ellen's head to the board of directors. You can go to probably any one of the 3 board members, and I think that'll be fine. Linda saw many other provisions because, of course, she's got experience in representing small businesses, which is why nonprofit is the client. In the draft agreement that were more favorable to Ellen than those in a typical agreement. Well, clearly their interests are adverse, just like a husband and wife retaining the same lawyer, or fiancés obtaining the same lawyer for a premarital agreement. Your interests are diverse. I know things are all happy right now, but 10, 20 years from now, or whenever you're going through a divorce, you're going to wish that you had your own attorney for that premarital agreement, so it's a potential conflict down the road. Same thing with the partnership, exact same thing. Linda arranged a meeting with the nonprofit board to discuss the terms of Ellen's employment agreement. Good. The board chair asked Linda to invite Ellen to attend the board meeting and join the discussions. I would tell the board member, the board chair, that, hey, look, there's a conflict here. Your interests are adverse and different than the employees. So I don't think it's a good idea to have Linda there. So I wouldn't recommend that she being there. All right, I mean, that's it. We're done. We just wrapped it up. So who's the client? Nonprofit. And at that time, Linda should have explained everything to Ellen so that Ellen was clear who her attorney was, that she represents the corporation and not Ellen individually, and that Ellen should seek her own independent counsel. Also, our discussions are not privileged. So anything you tell me, I have to go to the corporate, I have to do what's in the best interest of the corporation. There's a potential conflict there. The agreement does not have to be in writing, no matter how you slice it. That's it, we're done. Easy peasy.